In this lecture, we shall discuss judicial remedies. Judicial remedies. And we shall discuss this within the context of the Ghana legal systems and methods. The Ghana legal systems and methods. So what are judicial remedies? Now, when you look at the Black's Law Dictionary, the 9th edition, it defines remedies as follows, and I quote, the means of enforcing a right or preventing or redressing a wrong, legal or equitable relief, and the quote ends. It means that if we talk about remedy, we are referring to the means you have as a person to enforce a right you have a law or to prevent a wrong from being occasioned. Now, what is important to note is that what we shall do in this lecture is that we shall discuss these remedies under two main headings. First, we shall discuss what has come to be known as private law remedies. And then over there, we shall look at remedies like actions for damages, injunction, declarations. And also, we shall look at public law remedies, where we shall be looking at things like rates of prohibition, rates of certiorari, rates of mandamus, quo warranto, and habeas corpus. And so we shall begin with injunctions. Now, an injunction is essentially an order made by a court of competent jurisdiction, which order is directed against a particular individual or a group of individuals, and it is requiring such an individual or group of individuals to either stop or desist from engaging in a particular act. So it's either stopping them or restraining them from engaging in a particular act, or it is directing that such persons mandatorily carry out a particular act. And so it is important to know that when we refer to injunction, we are not only referring to always stopping or restraining a person from engaging in a particular act. An injunction could also compel somebody to engage in a particular act. Now, when an injunction is acting the person to cease or to stop engaging in a particular way, it is referred to as a prohibitory injunction. So when the essence of the injunction is that it is saying that somebody should not engage in a particular act, then the injunction is one we can describe as a prohibitory injunction. But when the injunction is in essence compelling a person to engage in an act, then the injunction will be described as a mandatory injunction. So for example, if you want to restrain a person from interfering with your land, the kind of remedy you will obtain may be the prohibitory injunction, because you are prohibiting and restraining the person from interfering with the land. But if the person has engaged in the act, constructed an offending wall, and then you are asking the court for an order to compel the person to remove the wall from there, to remove the container from the land, then in that instance, you can go for a mandatory injunction, because a mandatory injunction is compelling a person to engage in a particular act. Now, one thing that I need to bring to your attention is that if an injunction is a prohibitory injunction, or whether the injunction is a mandatory injunction. The injunction that is granted, whether it be a prohibitory injunction or a mandatory injunction, it can either be an interlocutory injunction or a permanent injunction. Now, let me explain this to you. Now, it is tried law that before any person can invoke the court's jurisdiction to ask for an injunction, then there must have been a substantive case pending before the courts. So let's say you have brought an action against a person seeking for an order of declaration of title to your land. And that matter is pending before the courts. And you know, the average lifespan, if it's in Ghana, maybe the case is scheduled to last for about 3 to 5 years. But while you are asking for this declaration of title to land, the person is exhibiting an intention of going onto the land to develop same. So while the matter was pending before the court, the defendant has gone onto the land with his workers and they have started digging and they started building. In that case, remember that you have already brought an action against him seeking for a declaration of title to land. Now, if in the meantime, you wish to go and obtain an order from the courts to restrain him from going ahead with the development, then you can go for an interlocutory injunction. So you can go for an interlocutory injunction, but in this case, this interlocutory injunction you are obtaining, it is the nature of a prohibitory interlocutory injunction. Why do I say so? This is because you are prohibiting the defendant from engaging in a particular act pending the final determination of the case. So when the essence of the injunction is that you are restraining a person from engaging in a particular act, it is a prohibitory injunction. Except that in this case, the time this injunction is being granted is that it is granted during the pendency of the substantive action. The main action has not yet been completed, but you are injuncting the person pending the final determination of the action. It is called an interlocutory injunction. And remember, like I said, this interlocutory injunction is a prohibitory interlocutory injunction. But when the case is head to its finality and the court adjudges you to be the rightful owner of the land, then that's when you cannot be granted a permanent or a perpetual injunction, restraining the defendant, his agent, assigns, PVs, any person claiming whatsoever under them from interfering with the land in any way. Why is that one permanent? That one is permanent because the case is over. You have been adjudged to be the owner. There's nothing more left to be discussed. So at the end of the case, when you have been adjudged to be the owner, we can grant you a permanent or a perpetual injunction. But when the matter is pending, all we can grant you will be an interlocutory injunction. So by way of recap, what we said is that an injunction can be an order of the court directed against a person or group of persons, requiring them to either abstain or to restrain them from engaging in a particular conduct, or directing them to engage in a particular conduct. Now, if the essence of the injunction is that it is seeking to restrain a particular person from engaging in an act, then it is a prohibitory injunction. But if the essence of the injunction is that it is requiring a person to carry out a particular act, then it is a mandatory injunction. Now, whether it be a prohibitory injunction or a mandatory injunction, it could either be interlocutory or it could be perpetual. If it's an injunction which is granted during the pendency of the case, then it can be called an interlocutory injunction because not the main injunction you are getting when the rights have been fully heard. But when the case is over and the rights of the parties have been fully determined, and we know who the land belongs to and who it doesn't belong to, the court can then grant a perpetual injunction or a permanent injunction. In the same way, a mandatory injunction. Remember, a mandatory injunction is one that is requiring somebody to engage in a particular act. That mandatory injunction can also be interlocutory or it can be perpetual. So that if the mandatory injunction ordering a particular person to carry out an act is made during the pendency of the case, it can be called an interlocutory mandatory injunction. But if the mandatory injunction is being granted after the case is over and the rights of the parties have been fully heard, we can call that a perpetual mandatory injunction or a permanent mandatory injunction. Now, we will not go into the requirements to grant an injunction because that will be a subject matter of another discussion. But it is good that for now we know the different kinds of injunction we can get and the descriptions for each of them. I'm sure by now we must have heard of interim injunctions. Interim injunctions. Now, under Ghanaian law, if you have an action, and let's say you have an action against a particular person, you wish that due to the exigency of the particular matter, you wish that you would obtain an injunction as quickly as possible, and that you know that if you say you're not going to serve the person, it may take forever, and before you realize the breach you are complaining of would have already been carried out, then in that instance, you can go to the court and obtain an interim injunction. And usually for interim injunctions, you go on an ex parte application. When I say ex parte application, it means that you go without giving the other party notice. So for example, if Kofi has a cause of action against Amma, Kofi will not even tell Amma anything. Kofi will just run to the court without giving Amma notice, go to the court and then obtain an ex parte injunction. And once that ex parte injunction is granted, Amma will just be at home one early morning, they knock on the door and then they bring an order from the court that she has been injuncted on an interim basis from engaging in a particular act. Now, because of our fundamental principles in our legal system that every party must be given a right to be heard, we don't want people to be condemned that way by being injuncted when they've not even been heard at all. So when you go ex parte and you obtain an interim injunction to maintain a status quo, now that interim injunction that you obtain under our rules is supposed to last for only 10 days under Order 25 of the High Court Civil Procedure Rules 2004 CI 47. The interim injunction is supposed to last for only 10 days unless it is extended by the courts. So usually once you go and you obtain the interim injunction, then within that 10 days, you now file the application for injunction on notice and give the other party notice and let the other party come and they respond to the injunction so that we can go into the merits of the injunction application. So if you go ex parte and then you go and obtain it, we usually refer to it as interim injunction and it will only last for 10 days. So we know prohibitory injunction now. We also know mandatory injunction. And then we know that whether prohibitory or mandatory, it can either be interlocutory or permanent. Now, and remember I said these are private law remedies. They can apply between private individuals. Now, the next thing that we can look at is declarations. Declarations. Now, for declarations, they are essentially remedies granted by a court of competent jurisdiction. And this declaration is one that clarifies the respective rights of the parties. It clarifies their respective obligations without necessarily making an order against a party to either do or abstain from doing something. So there's a conflict between two persons and you want to ascertain whether one person has breached the contract. When you bring the action before the court, you seek for a declaration that Amma, by refusing to deliver the bottles of Coke on this said day, I are seeking a declaration that her failure to deliver the Coke shall amount to a breach of the contract. So the moment the court grants you that declaration, a declaration that Amma, by failing to deliver the coke on the 1st of January for the New Year celebration, breach the contract, the court, all they are doing is that they are clarifying the respective rights of the parties, they are clarifying the respective obligations of the parties, and they are not necessarily made an order against any person or party to either do or abstain from doing something. Now remember that even though I have mentioned that declarations are in essence private law remedies, today declarations or declaratory orders have been also obtained as public law remedies. This is because of human rights and administrative law issues. Declarations is a remedy that developed from the common law courts. And like I said, it is only for the purpose of clarifying the respective rights of the parties without necessarily ordering a particular person to do or abstain from doing something. If you want to order a private individual to abstain from doing something, you go for an injunction. But if you want to say that you want a declaration that will clarify whether whatever has happened is a breach of contract, then you rather go for a declaration. Now, if you look at Article 2 of our Constitution, for example, it has given every person who's a citizen of Ghana locus standi that you can bring an action before the Supreme Court to seek for a declaration that anything that has been done or has been done is in contravention with the 1992 Constitution. Now, remember I said for declaration, when you go for it, you're not directing a person to do or abstain from doing something. You are only saying that whatever they are doing, they are clarifying the respective rights and obligations of the parties. So you can seek for a declaration that whatever this person is doing is unlawful. Once that declaration is granted, it means that we now know that when he failed to do this and this on this particular day, what he did was unlawful. So declarations are only clarifying the respective rights and obligations of the parties. Remember the 31st December case, for example, that is the New Patriotic Party and Attorney General 31st December case. If you remember that case, the MPP were seeking a declaration from the Supreme Court that the celebration of 31st December as a national holiday with state funds was unconstitutional. Now, that was the essence of one of the reliefs, that they are seeking for a declaration that it is unconstitutional, because prior to that, there was a controversy about whether it was constitutional or not. Even in the case itself, there were 9 judges. 5 said it was unconstitutional, 4 said it was constitutional. It means that there was a controversy. So the declaratory relief is what to settle it, to let everybody know what your respective rights, what your respective obligations are. That is what we have as declaratory reliefs. So usually, if you obtain the declaratory relief, to give effect to it, then you can accompany it with now an application for an injunction. So usually you see relief 1, declaration that the intended celebration of 31st December as a national holiday is unconstitutional. Then relief 2 will now be an injunction restraining the defendant's agent assigns from celebrating 31st December with state funds. So the declaration in itself, that means that if you go and seek for a declaration alone, the court will only clarify the respective positions. But usually to give effect, then you must go ahead and then seek for an injunction as well, especially if it's a private law remedy, that you want to restrain the person as well. Having been declared unlawful, you want to restrain the person as well from going ahead to engage in that particular act. But if you go for the declaration alone, the declaratory order alone, it will only have the effect of clarifying the respective rights and obligations of the parties without ordering a person to do or abstain from doing something. But when you accompany a declaratory relief with an order for injunction, then you can restrain a person from engaging in a particular act as well. Let me just mention over here that under Article 2 of our 1992 Constitution, when a person brings an action to the Supreme Court and then he's granted a declaratory relief, the Supreme Court, knowing very well that if they just grant a declaratory relief, it is not requiring a person to do or abstain from doing something. If you look at Article 2, Clause 2 of the 1992 Constitution, it says that the Supreme Court shall, for the purpose of a declaration under clause 1, make such orders and give directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. Meaning that once they grant that declaratory relief, in order to make it effective, they can go ahead to make some orders to direct a person to restrain himself from engaging in a particular act or not, in order to give effect to that declaratory order. That is why we are saying that as for the declaratory order alone, it is not required a person to do or abstain from doing something. And that's why usually we accompany with the request for further orders. And then Article 2, Clause 2 of our Constitution, we've seen over there, that for purpose of giving effect to such a declaration, the court may make such orders and give directions as it thinks fit. It is important to note that when the Supreme Court gives these orders and you fail to carry it out, as for that one, it constitutes a high crime under the Constitution. And in the case of the president, it can even be a ground for removal from office. That is in the case of the president or the vice president. So when the Supreme Court grants a declaration under Article 2 and they give their orders, it is a very serious order that if you fail to carry out, it shall constitute a high crime, which in the case of the president and the vice president, if you read Article 2, Clause 4 of the 1992 Constitution, shall be a ground for removal from office. So we've dealt with injunctions, we've dealt with declarations. Now, these are, like we said, private law remedies, except that today, in contemporary times, both injunctions and declarations, people are seeking for them as public law remedies, especially because of administrative law and human rights issues. And under common law, it is generally known that people could also go for damages as private law remedies. So that's another private law remedy that we can also look at. So 3 so far: damages, declarations, and then injunctions. Now let's try and then touch on the public law remedies. Now in English law, when we say prerogative writs or prerogative remedies, then it has a technical meaning. The moment you hear prerogative writs, prerogative remedies, in English law, we are referring to the writs of habeas corpus. We are referring to the writs of certiorari. We are referring to the writ of prohibition. We are referring to the writ of mandamus. We are referring to the writ of quo warranto. These are strictly public law remedies, and they are not available in private litigation. In other words, you cannot go and sue your brother who is a private individual, not acting in any public capacity. You cannot go and sue him and say that you're asking for a certiorari or you're asking for a mandamus. Those remedies, those writs do not operate in private law settings. They are strictly public law remedies, and therefore they're not available in private litigation. They are therefore only available against public officials, statutory bodies, governmental agencies, as well as constitutional bodies. So when we say prerogative writs, prerogative remedies, we are referring to habeas corpus, certiorari, prohibition, mandamus, quo warranto, and like we said, these are strictly public law remedies and are not available in private litigation. Now, in the Republic of Ghana, these prerogative writs, these prerogative remedies, they are available under 2 main circumstances of our Constitution. Now, depending on how you look at it, you may either make it 2 main circumstances or you may make it 3 main circumstances, and I explain why. The first circumstance is under the human rights jurisdiction of the High Court under Article 33, Clause 2 of the Constitution. You know, Article 33, Clause 1 of our 1992 Constitution indicates that where a person alleges that a provision of this Constitution on the fundamental human rights and freedoms has been or is likely to be contravened in relation to him, then without prejudice to any other action that is lawfully available to that person may apply to the higher court for redress. So under Article 33 Clause 1, the person whose human rights is likely to be breached or is being breached is given the right to apply to the higher court for redress. Now, if you look at Article 33 Clause 2, and this is where the interesting point is, and I'm going to quote in extenso what Article 33 Clause 2 says, and I quote as follows. The High Court may, under Clause 1 of this article, issue such directions or orders or writs, including writs or orders in the nature of habeas corpus, certiorari, mandamus, prohibition, and quo warranto, as it may consider appropriate for the purpose of securing or for the purpose of enforcing or securing the enforcement of any of the provisions on the human rights and freedoms as to the protection of which the person concerned is entitled. And the end of quote. Now you realize that under Article 33 Clause 2, for the purpose of the High Court enforcing a person's fundamental human rights, the High Court is empowered under Article 33 Clause 2 to issue such writs, including writs in the nature of habeas corpus, certiorari, mandamus, prohibition, and quo warranto. So under Article 33 Clause 2, the High Court is given the power to issue these writs. So that is the first mode or bound under which these prerogative writs can be granted in Ghana. That is in the High Court exercise of its exclusive original jurisdiction in enforcing fundamental human rights and freedoms of persons. Now, the second ground or circumstance under which these remedies may be issued in the Republic of Ghana is when you invoke the supervisory jurisdiction of the High Courts under Article 141 of the Constitution, and also when you invoke the supervisory jurisdiction of the Supreme Court under Article 132 of the Constitution. So look at Article 141 of the Constitution, and what does it say? It says that the High Court shall have supervisory jurisdiction over all lower courts and any lower adjudicating authority, and may, in the exercise of that jurisdiction, issue orders and directions for the purpose of enforcing or securing the enforcement of its supervisory powers. And the quote ends. Meaning that if you invoke the supervisory jurisdiction of the High Court under Article 141, and it's against a lower adjudicating authority or a lower court, the High Court has the power to issue such orders and directions, which will be necessary for the purpose of enforcing or securing the enforcement of such supervisory powers. So what are some of the orders and directions the High Court can issue over such adjudicating bodies? They can issue a certiorari to quash a decision taken by an administrative body. They can issue a writ of prohibition to restrain the lower court or the administrative tribunal from going ahead to perpetrate an illegality. Or they could also issue an order of mandamus against a particular public officer to compel him to engage in a particular act. So Article 141 is a key provision that gives us the circumstance under which the supervisory jurisdiction of the High Court can be invoked. And when you invoke that supervisory jurisdiction, the High Court has the power to issue some orders and directions for the purpose of securing and enforcing any of its supervisory powers. That's Article 141 of the Constitution. And you have also the supervisory jurisdiction of the Supreme Court under Article 132 of the Constitution. Article 132 of the Constitution reads as follows, and I quote, "The Supreme Court shall have supervisory jurisdiction over all courts and over any adjudicating authority, and may, in the exercise of that supervisory jurisdiction, issue orders and directions for the purpose of enforcing or securing the enforcement of a supervisory power. Quote ends. Now take a critical look at Article 132 of the Constitution. It says the Supreme Court is given supervisory jurisdiction, and it's against whom? It's against all courts and over any adjudication authority. So if it's over all courts and any adjudication authority, the Article 132 further says that, and then in the exercise of that supervisory jurisdiction, they can issue such orders for the purpose of enforcing the supervisory power that they've been given. Now, if you say they shall issue such orders, what are some of the orders? If the Supreme Court is supervising the Court of Appeal, the Supreme Court can grant a writ of certiorari to quash a decision taken by the Court of Appeal. If the Supreme Court you've invoked the supervisory jurisdiction of the Supreme Court over the High Court, the Supreme Court can grant the prerogative writ of certiorari to quash the decision taken by the High Court. So, if you invoke the supervisory jurisdiction of the Supreme Court under Article 132, they can also issue such orders or directions as they think fit. Now, when you take a critical look at Article 141 and 132 of the 1992 Constitution, it appears that there's some overlap somewhere. For example, Article 141 gives the High Court supervisory jurisdiction over all lower courts and adjudicating bodies. And when you take a look at Article 132 of the Constitution, it gave the Supreme Court supervisory jurisdiction over all courts and adjudicating bodies. So whereas the High Court has been given supervisory over all lower courts, and the lower courts in our Constitution, you know that they are the ones established by an Act of Parliament. So in our case, they've been established under the Courts Act, and they include the Circuit Court, the District Courts. And so under Article 141, the High Court is given supervisory jurisdiction, not over all courts, but rather of only lower courts and adjudicating bodies. And the 132.2 of the Constitution gives the Supreme Court supervisory jurisdiction over all courts and adjudicating bodies. So the question then is that if a person is seeking to challenge an administrative conduct or is seeking to impugn the decision of an adjudicating body, can the person go under Article 132 and go straight to the Supreme Court? Because Article 132 gives the Supreme Court supervisory jurisdiction over all adjudicating bodies. Can a person go straight to the Supreme Court? Or for example, if a person is in the Circuit Court and then he wants to impugn a decision of the Circuit Court, can the person go straight to the Supreme Court and invoke Article 132 and say that Article 132 gives you, the Supreme Court, supervisory jurisdiction over all courts? And so I'm coming straight to you to invoke your supervisory jurisdiction. Or must the person go to the High Court first? In other words, considering the overlap between Article 141 and 132, can the person go straight to the Supreme Court, or the person must go to the High Court first? Now, the answer to this question is that when the Constitution gives concurrent jurisdiction to the High Court and the Circuit Courts, then there is a practice direction, which is to the effect that you must first invoke the jurisdiction of the lower court, which in this case is the High Court. You must first invoke the decision of the jurisdiction of the lower court first, before you be allowed to invoke the jurisdiction of the one above. Now, this practice direction has been affirmed in the case of Republic versus Numapau. Numapau is spelled N-U-M-A-P-A-U. N for nice, U for under, M for mango, A-P-A-U. Numapau and others versus Numapau and others, ex parte Ameyao. So Republic versus Numapau and others, ex parte Ameyao, the second, reported in 1999-2002 two Ghana law reports at page 629. Republic versus Numapau and others, ex parte Ameyao, the second, reported in 1999-2000 through Ghana Law Report at page 629. And this is what the case says, and I quote: "There's a well-established practice of the Supreme Court which required that when a cause or matter could be determined by a superior court other than the Supreme Court, the jurisdiction of the lower court should first be invoked." And the quote ends. It means that even though the High Court is giving supervisory jurisdiction over lower courts and adjudicating bodies, and the Supreme Court is giving supervisory jurisdiction over all courts, if you're in a district court and you want to supervise the jurisdiction of the district court, even though technically, and that's 132, you can go straight to the Supreme Court, there's a practice direction saying that in view of the fact that there's an overlap or there's some concurrence that the Supreme Court has with the High Court, you must first invoke the jurisdiction of the High Court first under Article 141 before you can come to the Supreme Court. And this practice direction has been affirmed in the case of Republic versus Noma Powell and others. Ex parte, Amayal II, reported in 1999-2000 through Ghana Law Report at page 629. But take note of the difference. Even though the High Court is giving supervisory jurisdiction under Article 141, theirs is for the purpose of supervising lower courts and adjudicating bodies. It means that the Supreme Court that is given the power to supervise all courts. The difference between Article 132 and 141 is that the Supreme Court is given the power to supervise all courts, meaning that the Supreme Court can supervise the High Court and the Court of Appeal, but the High Court cannot. So that if you are in the High Court and you want to supervise the jurisdiction of the High Court, that's when you rather go straight to the Supreme Court. The Supreme Court is given more or less exclusive jurisdiction when it comes to granting supervisory orders against the High Court and the Court of Appeal. So even though there's an overlap between Article 132 and 141, there's a difference. Because 141 deals with supervising only lower courts and adjudicating bodies. But 132 deals with supervising all courts and adjudicating bodies. And the all courts includes also the High Court and then the Court of Appeal. So the distinction between 132 and 141 is that 141 gives only to the High Court, and the High Court is supervising only lower courts and adjudicating bodies. But when it comes to 132, the Supreme Court can supervise all courts, including the High Court and the Court of Appeal. So that's one difference that you should take note of. So we've been able to see at least three main circumstances under which these prerogative orders can be granted. One, we've seen it under Article 33, Clause 2, that these orders can be granted in the course of enforcing a person's fundamental human rights. Again, remember that these orders can be enforced when you invoke the supervisory jurisdiction of the High Court under Article 141. And then also it can be granted when you invoke the supervisory jurisdiction of the Supreme Court under Article 132. Now, please do not take the High Court one for granted at all, because if you remember, in the days of area Kotu, when J.B. Dankwa applied for habeas corpus for area Bafo, Kotu, and the others, when he applied for the habeas corpus, the court held that the constitution of the 1960 Constitution of Ghana, it didn't make it enforceable to just come and say you're coming for habeas corpus, even though you may be alleging a breach of a person's fundamental human rights. And so they didn't grant the habeas corpus when the action was brought under the 1960 Constitution. And so to avoid those circumstances, that is why today we have made it very explicit, clear in our Constitution, under Article 33, Clause 2, that if you are enforcing human rights provisions, the High Court has the power to also grant habeas corpus, so that we don't go back to the days of area Kotu. So you've seen at least three circumstances under which these prerogative writs can be granted. And Article 33, Clause 2 in enforcing human rights provisions, and Article 141 in invoking the supervisory jurisdiction of the High Courts, and under Article 132 in invoking the supervisory jurisdiction of the Supreme Court. So now that we've seen the circumstances under which these orders may be granted, let us now see what the meaning of all these prerogative writs are. These prerogative writs of certiorari, mandamus, prohibition, quo warranto, habeas corpus, what are they? who can apply for them, and what are the requirements that a person must establish before he can be granted any of these prerogative writs. The first that we shall look at is certiorari, which is also known as the quashing order. Certiorari, which is also known as the quashing order. Now, a certiorari is essentially an order which is granted to nullify a decision which has been made by a public body. You are nullifying or you are quashing a decision which has been made by a public body. Now, take note that as for certiorari, the decision has already been made. And you are saying that that decision is a nullity. So you are bringing an action to get a writ of certiorari to quash that order and declare it as a nullity. That is what the writ of certiorari is. So that if you invoke the supervisory jurisdiction of the High Court under Article 141 over the lower court, you can be saying that the decision of the lower court is a nullity. So you want it to be quashed straight away. So when we say you are invoking the supervisory jurisdiction for a writ of certiorari, what are the grounds under which you can come for this writ of certiorari? Now, there are a number of grounds. One ground is when there is want or excess of jurisdiction. In other words, if it is your case that the district court was hearing a particular matter and they didn't have jurisdiction to, for example, interpret or enforce the Constitution, and they've gone ahead to interpret or enforce the Constitution, it means that they have exceeded the bounds of their jurisdiction. If they have exceeded their bounds of their jurisdiction, what do? Go to the High Court and apply for a writ of certiorari, and then quash whatever they have done, because what they didn't have jurisdiction to do so. So when you say want of jurisdiction, it means that they didn't have the jurisdiction. If you say excess, it means that you had, but you exceeded your jurisdiction. So when the lower court or administrative tribunal acts in excess of his jurisdiction, you can invoke the supervisory jurisdiction of the High Court under Article 141 to have same quashed. In the same way, if it's a High Court as well, that exceeded its jurisdiction, so that the High Court is the one that was given a decision, but they exceeded their jurisdiction by going ahead to interpret the Constitution or to enforce to interpret the Constitution. When you know that that interpretation jurisdiction had been reserved for the Supreme Court, what do? You can invoke the supervisory jurisdiction of the Supreme Court under Article 132 to have the decision of the High Court quashed. So that's one ground under which you can grant certiorari: want or excess of jurisdiction. We also have breach of the rules of natural justice, so that if the lower courts or adjudicating body gave a decision which was in breach of the rules of natural justice, what do? If the district court, you can apply to the High Court under Article 141 to invoke their supervisory jurisdiction to quash that decision taken by the district court. If it's the High Court or the Court of Appeal who has given a decision and it was in breach of the rules of natural justice, what do? You can invoke the supervisory jurisdiction of the Supreme Court under Article 132 to quash that decision that was taken by the High Court. So breach of the rules of natural justice is another ground under which the court can grant the remedy of certiorari. Then the next ground is that when there's an error of law which is patent on the face of the record, it's also another ground under which you can apply for a certiorari. Also, if there's also an illegality, a decision that has been taken which is contrary to statutes, it is contrary to the express dictates of the statutes, you can also apply for a writ of certiorari. So there are a number of them, and we'll take each of these ones one after the other, and then explain them in terms of the applicable case law and how they'll deal with all of these grounds. But remember that we said that these writs can be issued by both the High Courts and also the Supreme Court. So I'll be reading now some cases to you, but take note of the cases, because some of the cases that we'll read will be laying down the grounds under which the Supreme Court may grant these prerogative writs. Some too will be dealing with the High Courts in terms of the High Court granting these prerogative writs. So you should take note of them carefully. Now, for the grounds under which the Supreme Court may grant an order of certiorari, I refer you to the case of Republic versus High Court Kumasi, ex parte Apia and others, reported in 1997, 98, One Ghana Law Report at page 503, where the Supreme Court stated as follows, and I quote, "There is, however, power given to the Supreme Court to exercise supervisory jurisdiction over all courts, including the High Courts and any adjudicating authority, and may, in the exercise of such jurisdiction, issue orders and directions for the purpose of enforcing or securing the enforcement of its supervisory powers under Article 132 of the Constitution, 1992. Consequently, if it is found that the High Court, in exercising its jurisdiction, has breached any of the rules of natural justice, or on the face of its orders erred in law, or has acted in excess of its jurisdiction, or lacks jurisdiction in the matter it has acted on, this court would have the power to order the removal of those proceedings before it, for the purpose of having those proceedings quashed. It must be stated, however, that a prayer for the grant of certiorari must be considered from a very broad perspective, and that's being a discretionary power, it must be shown that there is a real justification for its grant. So when you read this case of Republic versus High Court Kumasi, ex parte Apia, what are some of the grounds that we can see that have been mentioned under Article 132 in terms of the grounds under which the Supreme Court can grant an order of certiorari? It was mentioned that we can go for certiorari if the High Court has breached any of the rules of natural justice. It was also mentioned that an order of certiorari can be granted if, in exercising its jurisdiction, the High Court has committed an error on the face of its orders. And also, it can be granted if the High Court has acted in excess of its jurisdiction, or if the High Court lacks jurisdiction in the matter it has acted on. Then for all of these things, those orders can be brought to the Supreme Court for purpose of being quashed. Also take note that the Supreme Court mentioned that the grant of an order of certiorari is discretionary, and then it will only be granted if it is shown that there's a real justification for its grants. And then if you look at the case of Republic versus High Court, second D, ex parte Ampon, aka Akrofa Kukoko the First, Chirefo the Third, and others interested parties, 2011, 2 Supreme Court of Ghana Law Reports at page 716, specifically at page 722. The following was said about certiorari, and I quote, that an order of certiorari, it is right learning, is a discretionary remedy granted on grounds of excess or want of jurisdiction, and or some breach of a rule of natural justice, end of quote. Another case, in the case of Republic versus Cape Coast District Magistrate, grade 2, ex parte Amu, reported in 1979 Ghana Law Reports at page 150, Court of Appeal, Apalu CG, noted as follows on certiorari applications, and I quote, Apalu CG, and this is the case of Republic versus Cape Coast District Magistrate, grade 2, ex parte Amu, 1979 Ghana Law Reports at page 150. This is what Apalu CG said, and I quote, as is well known, the remedy of certiorari is a useful tool in aid of justice and ought to be used to correct defects of justice, whether they arise from illegality, fraud, breach of the rules of natural justice, error on the face of the record, and the like. I'm not even prepared to say that the category of cases in which this useful remedy can or should be used is closed. There's no reason why I should stifle the development of the law by any such assertion. Quote ends. So what is Apalu CJ saying? He's saying that when there's a decision which is arising out of an illegality, so for example, when you've taken a decision as a district court, and it is contrary to the express requirement of a statute, we can say that decision is illegal, and we can correct it by a writ of certiorari. We can quash it. Apollo CJ says that when there's a breach of the rules of natural justice, we can use certiorari as a tool to quash that decision. Or when there's an error on the face of the record, Apollo CJ says that we can quash the decision by a writ of certiorari. And it makes a very important point that he's not even prepared to say that the category of cases in which this useful remedy can be used should be closed. So he's trying to say that it's not as if there's a closed room, closed compartment, or limited grounds under which you can come for this. The court will continue to expand on them if it is for the purpose of doing justice and to prevent illegal decisions from being taken. That is why it's called supervisory jurisdiction. Also important to look at is the case of Republic versus High Court, Accra, ex parte chargé d'affaires, Bulgarian Embassy. All reported decisions used number J5/34/2015. And the decision is dated 24th February 2016. And this is what the Supreme Court said. And I quote, "It is well settled that certiorari will be granted to quash a decision of a court that has been made without jurisdiction or in excess of jurisdiction, or when there's an error of law apparent on the face of the record that makes the decision a nullity. Certiorari will also be granted to quash a decision given in breach of a rule of natural justice." Quote ends. So this is the case of Republic versus High Court Accra, ex parte chargé d'affaires, Bulgarian Embassy. And what are they saying? That certiorari will be granted to quash a decision of a court that has been made without jurisdiction. That's one. In excess of jurisdiction. Two, error of law apparent on the face of the record. Error of law apparent on the face of the record. Number three. And these things make the decision a nullity. And they're saying that certiorari will also be granted to quash a decision given in breach of the rules of natural justice. And like this case or not, Republic versus High Court Accra, ex parte chargé d'affaires, Bulgarian Embassy. I'll read it again. It says that it is well settled that certiorari will be granted to quash a decision of a court that has been made without jurisdiction or in excess of jurisdiction, or where there's an error of law apparent on the record that made the decision a nullity. And the certiorari will also be granted to quash a decision given in breach of a rule of natural justice. So at least we see some grounds in this ex parte chargé d'affaires. That's one, lack of jurisdiction. Two, excess of jurisdiction. Three, error of law apparent in the face of the record. Four, breach of the rules of natural justice. Republic versus High Court Accra, ex parte chargé d'affaires. And I believe you note that in referring to the grounds under which we can apply for certiorari, when we spoke about Article 141 and then 132, we saw that it's not only courts against whom it can be granted, it can also be granted against adjudicating bodies or administrative tribunals. So I need to refer to a particular case in which it was extensively discussed about the grounds under which the court may intervene, especially when it is in relation to administrative bodies or some adjudicating bodies. And this is the case of Council of Civil Service Unions and others versus the Minister for the Civil Service, reported in 1984, 3 All England reports at page 935. In this case, Lord Diplock at page 949 noted as follows, and I quote, "To qualify as a subject for judicial review, the decision must have consequences which affect some person or body of persons other than the decision maker, although it may affect him too. It must affect such other person either A, by altering rights or obligations of that person which are enforceable by or against him in private law, or by depriving him of some benefit or advantage which either he has in the past been permitted by the decision maker to enjoy, and which he can legitimately expect to be permitted to continue to do until there has been communication to him, some rational ground for withdrawing it on which he has been given an opportunity to comment. Or he has received assurance from the decision maker will not be withdrawn without giving him a first opportunity of advancing reasons for contending that they should not be withdrawn. Lord Diplock goes on to say that for a decision to be susceptible to judicial review, the decision maker must be empowered by public law to make decisions that, if validly made, would lead to administrative action or abstention from action by an authority endowed by a law with executive powers, which have one or other of the consequences mentioned in the preceding paragraph. And the quote ends. Now, I know it's a long quote, but I'll summarize the grounds that have been mentioned by Lord Diplock in this case of Council of Civil Service Unions and others versus the Minister for Civil Service, when he was telling us the grounds under which we can apply for judicial review of administrative actions. Now, the first thing that I need to point out is that if you look at this case critically, now, Lord Diplock identified 3 broad categories of acts that can be amenable to judicial review. He looked at 3 broad categories of acts that may be amenable to judicial review. First category are acts that are illegal. This is because, according to Lord Diplock, if a person takes a decision in the performance of his public function, then that person must understand correctly that it is the law that is regulating the power to make that decision. So he must give a decision which is supposed to give effect to the law. So that if you can give a decision which is contrary to law, then it's a ground under which we can review your action by coming for judicial review, and we can apply for certiorari to quash that decision. So one ground that we can identify and glean from Lord Diplock's statements in the case of Council of Civil Service Unions and others versus the Minister for the Civil Service is that a decision which is illegal is the basis on which you can get a remedy of certiorari in an application for judicial review. The second we can get from Lord Diplock's statement is that the decision must be rational. In other words, if the decision is irrational, what has become known as Wednesday unreasonableness. If it is irrational, then it's a ground under which we can apply for judicial review and obtain a writ of certiorari to quash your decision. So if we talk about unreasonableness or irrational, we are referring to a decision of a public nature, which is so outrageous in its defiance of logic, or so outrageous in its defiance of acceptable moral standards that no reasonable person would have arrived at that decision. And so the second category looking at irrational decisions, what we know as Wednesday unreasonableness. And what do we mean by that? Decisions that are taken of a public nature and they are so unreasonable in their defiance of logic, or they are so unreasonable and outrageous in their defiance of acceptable moral standards that no reasonable person would have arrived at that decision. The third ground we can glean from Lord Diplock's statements is that it deals with procedural propriety, procedural fairness. I have mentioned so many cases so far in order to just bring to your attention and give you a fair idea about the grounds under which this remedy of certiorari may be granted. I have taken you through the case of Republic versus High Court Kumasi, as per the appeal. We've also gone through the case of ex parte Akofa Kukoko. We've gone through the case of Republic versus Cape Coast District Magistrates, grade 2, ex parte Amu. We've also looked at Republic versus High Court Accra, ex parte Chargé d'Affaires, Bulgarian Embassy. Now, if you go through all these cases, I believe by now you should see something that is common. I went through all of them to give you an indication as to the ground, to give you some confidence about the grounds under which a person can go for a remedy of certiorari. We've seen them, that when there's want or excess of jurisdiction, when there's breach of the rules of natural justice, when the decision is what? Illegal. And now we've seen in relation to administrative bodies that when it is what? Unreasonable within the Wensby principle, we can say that we can quash the decision by a remedy of certiorari. So it is important that you get to know all of these grounds so that when we take each of them one after the other and we are discussing them, you get a better idea of these grounds. Now, many a time, people just mention these grounds and they don't really know what goes into each of them. When we say breach of natural justice, you don't know what you're referring to. When we say error of law patent on the face of the record, you don't know what you're referring to. When we say want or lack of jurisdiction, you don't know what you're referring to. So we'll take each of these grounds and then discuss them extensively so that you know at least one case under each of them. First one that we'll go very fast with is when the decision is in breach of the rules of natural justice. This is quite straightforward. You know that natural justice essentially refers to those two principles of audi alteram partem, which means a party must be given a right to be heard, and also nemo judex in causa sua, which means that a judge must not have an interest in the outcome of the case that he himself is determining. So when there's a decision which breaches any of these rules of audi alteram partem or nemo judex in causa sua, then it's a decision that can be quashed by a writ of certiorari. And on this, I refer you to the case of Republic versus State Fishing Corporation, Commission of Inquiry, Chairman, ex parte Bannerman, reported in 1967, Ghana Law Report at page 536. Again, another ground that we can obtain a remedy of certiorari is when there's a fundamental error on the face of the record, or when there's a patent error on the face of the record. Now, this one is what has confused students a lot. And therefore, I'll walk you through at least two cases that would explain to you what we mean by fundamental error on the face of the record. The reason I want to draw this distinction is because it is not every error of law that when a judge commits, it will give you a ground to go for certiorari. It's not every error of law, because think about it. If it's just any error of law, some simple errors of law that the judges commit, you rather have to appeal against it. So I have to explain this very well, because after explaining this, you should know when you can go for an appeal and you should know when you can go for the prerogative writ of certiorari. It is not every error of law that will entitle you to go for the remedy of certiorari. And so I must explain this to you. And the moment I take you through these cases, you should have no doubt in your mind in knowing which errors of law will entitle you to go for certiorari and which ones will entitle you to go for an appeal. And on this, I refer you to the words of Wood JSE, Judge Nawood JSE, as she then was in the case of Republic versus Court of Appeal, ex parte Chachu Chikata, reported in 2005-2006 Supreme Court of Ghana Law Reports at page 612. When I read the words of the learned justice, you should have an idea about the kinds of error that if they are committed, this will entitle you to go for a remedy of certiorari. The case is Republic versus Court of Appeal, ex parte Chachu Chikata, reported in 2005-2006 Supreme Court of Ghana Law Reports at page 612, where the learned justice said as follows, and I quote, "The clear thinking of this court is that our supervisory jurisdiction under Article 132 of the 1992 Constitution should be exercised only in those manifestly plain and obvious cases where there are patent errors of law on the face of the record, which errors either go to jurisdiction or are so plain as to make the impugned decision a complete nullity. It stands to reason then that the errors of law alleged must be fundamental, substantial, material, grave, or so serious as to go to the root of the matter. The error of law must be one on which the decision depends. A minor, trifling, inconsequential, or unimportant error, or for that matter, an error which does not go to the core or root of the decision complained of, or stated differently, on which the decision does not turn, would not attract the court's supervisory intervention. Also, where the proceedings are regular, the charge that the court has misread or misconceived a point of law or misdirected itself does not per se constitute a sufficient ground for the grounds of the order. Similarly, the complaint that there has been an improper exercise of the discretionary jurisdiction is clearly insufficient. End of quote. Remember, before I read this case out, I mentioned that before we go through this case, I have to warn that it's not every error of law that will entitle a person to go for the judicial review in the nature of certiorari. It must be some particular kind of error. And we are told by Judge Nawu JSC in this case of Republic versus Court of Appeal, ex parte Tricata, reported in 2005-2006 Supreme Court of Ghana Law Report 612. We are told by the learned justice that this jurisdiction to quash on ground of certiorari, it should be granted only in those manifestly plain and obvious cases where there are patent errors of law on the record, and that the errors either go to jurisdiction. It means that the error the judge has committed, it is going to jurisdiction. It is going to show that the judge didn't even have jurisdiction to deal with the matter. That is why I gave an example earlier that if you're in the high courts and then they have committed an error of law by, for example, interpreting the Constitution. Now, this error of law they have committed, it goes to jurisdiction because we know that the jurisdiction to interpret the Constitution, by virtue of Article 2 and Article 130, it has been reserved exclusively for the Supreme Court. So if the High Court, in giving its decision, commits an error, and the error is that he has gone ahead to interpret the Constitution, then that is what you can call an error of law, which is so plain and obvious, and it goes to jurisdiction. Judge Nawood also says that the error complained of must be fundamental, it must be substantial, it must be material, it must be so grave or so serious that it goes to the root of the matter. So it's not just any kind of error. He says it must be fundamental, it must be substantial, it must be material, it must be so grave or so serious as to go to the root of the matter. That is when you can say you're coming for certiorari. But if the error is trifling, it is inconsequential, then please, your remedy is whether to go for an appeal and don't try and come for certiorari because we will not allow you. So this is for the ground that there must be an error of law patent on the face of the record. Many people just state this without knowing what kinds of errors. So please, whenever you are discussing this ground of fundamental error on the face of the record, remember that it's not just any kind of error. It must be fundamental, it must be substantial, it must be material, it must be grave, it must be so serious as to go to the roots of the matter. Judge Nawu say that the error must be one in which the decision depends. So if it is fundamental, it goes to the roots. It's as if it goes to the very foundation. That is the basis on which the whole decision is dependent. So we must quash it. So if the judge has misconceived a point of law, Judge Nawu is saying that your remedy is whether to go for an appeal and not to whether go for SSU. Right. So what are some of the ways in which a decision can be given that can be a complete nullity? For example, when the High Court or when the court gives a decision which is in violation of a constitutional provision or is in violation of an express provision of a statute, then that's one you can actually go for the remedy of certiorari to quash it on the ground that they have committed a patent error that is manifest on the record. What this means is that if the error in question does not get to this level of repugnance, in other words, if it doesn't get to this level of repugnance in the sense that if the error in question doesn't go to jurisdiction, it's not so material, it's not so grave, it's not so serious, it's not so fundamental, then please, you can't go for certiorari. You can rather go for appeal. And this has been captured in the case of Republic versus High Court Accra. Ex parte trash. Ado interested party. This is what the court said, and I quote. The restatement of the law may be summarized as follows. Where the High Court, or for that matter, the Court of Appeal, makes a non-jurisdictional error, which is not patent on the face of the record, the avenue for redress open to an aggrieved party is an appeal, not judicial review. Again, the restatement of the law may be summarized as follows. Where the High Court, or for that matter, the Court of Appeal, commits a non-jurisdictional error, which is not patent on the face of the record, within the meaning already discussed, the avenue for redress open to an aggrieved party is an appeal, not judicial review. In this regard, an error of law made by the High Court or Court of Appeal is not to be regarded as taking the judge outside the court's jurisdiction, unless the court has acted ultra vires the Constitution or an express statutory restriction validly imposed on it. End of quotes. What are we being told in this case of ex parte trash? We have been told that where a particular court or body has acted ultra vires the Constitution, or you have acted ultra vires an express statutory restriction that has been validly imposed on you, then your decision can be one that we can say that it's illegal and it's a fundamental base on which we can go for certiorari. We are also being told in this ex parte trash case that if the High Court commits an error, which is a non-jurisdictional error, which is not patent on the face of the record, then please, you don't come for certiorari. You either go for an appeal, because it's an error which does not go to jurisdiction and it's also not patent on the face of the record. And let me sum up this distinction by referring you to the case also of Republic versus High Court Accra, ex parte Industrialization Fund for Development Countries and another, reported in 2003-2004 Supreme Court of Ghana Law Report at page 348. And this is what the court stated, and I quote, "It is to be noted that there is a clear distinction between certiorari and appeal, which is lost on litigants and their lawyers. When the High Court, a superior court, is acting within its jurisdiction, its erroneous decision is normally corrected on appeal, whether the error is one of fact or law. Certiorari, however, is a discretionary remedy, which would issue to correct a clear error of law on the face of the ruling of the court, or an error which amounts to lack of jurisdiction in the courts, so as to make the decision a nullity. In the case of an error not apparent on the face of the ruling or those of fact, the avenue is by way of appeal." End of quotes. I believe by now we are all clear in our mind on when we can go for an appeal and when we can go for certiorari. If the judge was acting within his jurisdiction and committed an error of law, you go for appeal. But when the judge is one that goes beyond its jurisdiction and commits an error of law in that regard, you can go for certiorari. So these cases that I've mentioned are all for the purpose of explaining just one thing to you, what we mean by fundamental error on the face of the record. I've given you the case of Republic versus Court of Appeal, ex parte Chachikata. We've given you the case of Republic versus High Court Accra, ex parte Trash. And you've also given the case of Republic versus High Court Accra, ex parte Industrialization Fund for Development Countries and another. And they have all shown us when we rather have to go for certiorari and not an appeal. Now, another ground under which certiorari can be granted that we mentioned is want or excess of jurisdiction. And I want to explain this to you with a case law. Want or excess of jurisdiction. And I'll explain this to you with the case of Republic versus the High Court Denu, ex parte Avadali IV. reported in 1993-94, One Ghana Law Report at page 561, specifically at page 568. Now, the background to this case is that the High Court had assumed jurisdiction over a matter that more or less was a cause or matter affecting chieftaincy. And you know, these are matters that are supposed to be there for the chieftain tribunals. So this is what was said in the case of Republic versus High Court, Genu, ex parte, Abadali IV, reported in 1993-94 One Ghana Law Reports at page 561, specifically at page 568, and I quote, "It seems to me that the respondent's claim is basically a cause or matter affecting chieftaincy, over which the High Court had no jurisdiction, but framed under the color of a land dispute which is within that court's jurisdiction. In such situations, the court should decline jurisdiction. Otherwise, either certiorari or prohibition would lie to prevent it from wrongly assuming jurisdiction." End of quote. So this was a clear case of the High Court exercising some jurisdiction that it did not have. So we are told in this case of ex parte Abadali IV that if you assume jurisdiction you don't have, we can quash your decision by a remedy of certiorari to quash that particular decision. Now, if you also look at the case of Republic versus District Magistrate, Accra, ex parte Adiu, reported in 1972 two Ghana Law Reports, the court stated as follows, and I quote, "It is of vital importance to appreciate that the term excess of jurisdiction is used. It may mean that from the inception of the case, the court has no jurisdiction whatsoever because the nature of the case or the value involved is beyond its jurisdiction. But it may also mean that although the court has jurisdiction to hear the case, the orders which the court can pronounce are restricted by statute. If an order is therefore beyond the powers of the court, it is perfectly correct to say that it has exceeded its jurisdiction." So that's what I mentioned earlier, that if you're in the High Court and the High Court is supposed to be given the things that the High Court can do, and you go ahead and you go and interpret the Constitution, please, you have exceeded your jurisdiction. And as we've seen, is a ground under which a remedy of certiorari can be properly granted. So these two cases of Republic versus District Magistrate, Accra, ex parte Adiu, as well as the case of Republic versus High Court, Genu, ex parte Abadali, they are here to explain to you what we mean by want or excess of jurisdiction. Now, I don't know whether you remember, but when we look at the case of Republic versus Cape Coast District Magistrates, Grade 2, ex parte Amu, Apollo CJ indicated that he is not prepared to say that the category of cases in which the useful remedy can or should be used should be closed, and that there was no reason why he should stifle the development of the law by such an assertion. You remember, Apollo CJ said that. And then also, still in that particular light, the Supreme Court has made a very interesting pronouncement that they can intervene and issue these prerogative remedies and writs whenever they think that they have to intervene to do justice. In other words, even though we have seen that the grounds that it must be illegal, breach of natural justice, lack of jurisdiction, excess of jurisdiction, the Supreme Court is also careful not to limit the grounds, but they are saying that whenever the circumstances of the case require that they must intervene to do justice to their supervisory jurisdiction can be properly invoked. And over here, I refer you to the case of British Airways versus Attorney General. British Airways versus Attorney General. And you can look at this case specifically, which is reported in 1997, 98, One Ghana Law Reports at page 55, specifically at page 61. And this is what the learned Bamford Ado JSC said, and I quote, "Reliefs B and C, however, are in a different category altogether and ought to be considered under different principles under Article 132 of the Constitution, 1992, dealing with the supervisory jurisdiction of this court as stated in Articles 132 and 61 of the Constitution, 1992. This jurisdiction ought to be exercised in appropriate and deserving cases in the interest of justice. In the exercise of that supervisory jurisdiction, the Supreme Court may issue prerogative orders, as well as any appropriate orders and directions to lower courts to ensure the proper, lawful, and fair administration of justice in any matter which comes before it. This is the final court of the land, and the court in which is reposed the duty of interpreting the Constitution, 1992, as well as safeguarding the Constitution, including protecting and enforcing the guaranteed fundamental human rights and supervising all lower courts. It is therefore our constitutional duty to prevent or remedy any breaches of the human rights of persons who complain of such breaches or intended breaches in any matter before us by the exercise of our supervisory jurisdiction. A timely intervention by this court is required in this case where the plaintiff's right to liberty is being jeopardized or threatened. This is a necessary and efficacious way of enforcing the constitutional provisions equitably, expeditiously, and effectively. For this reason, in my opinion, that whenever in the course of any matter brought to this court, it is found that there exists in any lower courts any matter which would in the long run result in injustice or in illegality, it is the duty of the court to at once intervene and issue orders and directions with a view to preventing such illegalities or injustice even before they occur. This case appears to me to be one such case which requires our intervention by the granting of the two other reliefs requested by the plaintiffs, through the exercise of our supervisory jurisdiction under Article 132 of the Constitution, 1992. So, and the quote ends. So we see that even though we have been given some grounds already, like breach of natural justice, we've been given illegality and things, we are told that they are not leaving the doors closed, that whenever the Supreme Court deems it's expedient that they must intervene to do justice, they are being told in British Airways and another by Attorney General that the Supreme Court can intervene to do justice in granting these prerogative orders or any such orders that may be necessary in order to prevent such illegalities from going on. So that is why Balfour Adu here said that for this reason, it is my opinion that whenever in the course of any matter brought to this court, it is found that there exists in any lower court any matter which would in the long run result in injustice or in illegality, it is the duty of the court to at once intervene and issue orders and directions with the view to prevent such illegalities or injustice even before they occur. So the Supreme Court can always intervene whenever there's a need to prevent such injustice from occurring when it's apparent that the lower court is about to commit such an injustice. So, in summary, what have we said so far about the certiorari? We've mentioned that certiorari is a quashing order. We've mentioned that you can go for certiorari and Article 33 clause 2 or an Article 141 or an Article 132. When you look at the grounds under which can be granted, lack or want of jurisdiction, excess or want of jurisdiction, breach of natural justice, an illegal decision, that is a decision which is contrary to statute, an error of law manifest on the face of the record. We've also seen that the Supreme Court can intervene whenever there's a need for it to do justice. And then we've also seen that for administrative bodies, there's a Wensby on reasonableness. If it's unreasonable, Lord Diplock is saying that it's a ground under which you can come for a certiorari. Now, before we wrap up with the certiorari, it is important for us to note the people that have capacity to bring an application for certiorari. Who has locus standi to bring an action for certiorari? So, for example, if Kofi and Amma have the matter before the High Court, or let's say it's a criminal case and it's a republic against Amma, can a person who is not a party to the suit, for example, the complainant, bring an action to the Supreme Court to say that he's invoking the supervisory jurisdiction of the Supreme Court? Who are the persons that have locus standi to bring an action for certiorari at the Supreme Court? Now, the answer to this question is in the Supreme Court's case of Republic versus High Court, Human Rights Division. Ex parte Na Otua Swin. Na is spelled N-A-A, Otua is O-T-U-A, Swin is S-W-A-Y-N-E. Prince Kofi Amwabin, the Attorney General, DSP Idenderi, the Registrar Circuit Courts. And this was civil motion number J5/8/2015, dated 19 February 2015, where the court noted and answered the question. Now, what I'm about to read will let you know that it is not only parties that can bring an application for certiorari. In other words, even though it may be the Republic versus AMA, this case will let us know that it's not only the parties to the suit that can invoke the supervisory jurisdiction of the Supreme Court to quash the High Court decision, but there could be other parties. So I want you to listen carefully. By the time I finish reading, you should know the circumstances under which another person who may not be a party can bring an application of certiorari to quash a decision that he is not a party to. And you will see this in the case of, like I said, Republic versus High Courts, ex parte, now Otua Swin, Prince Kofi Amwabin, and then the names I mentioned. So this is what was noted, and I quote as follows. When the application was moved, learned counsel for the interested party, Mr. Addington, opposed it on several grounds. The first ground was that the applicant herein, now Otua Swin, who was the complainant in the case, has no capacity to invoke our supervisory jurisdiction to quash the ruling of the High Court. We notice that this point of law was fully addressed by counsel for the interested party, but no authority was cited to support this contention. We wondered if this legal point could have availed him. This point of law is settled by authority. In the case of State versus Asante-Hines Divisional Courts, ex parte Kusada, reported in 1963 2 Ghana Law Report at page 238. The Supreme Court held, inter alia, that an applicant for an order of certiorari must either be a person aggrieved or a person who has a substantial interest in the proceedings sought to be quashed. I'll take that portion again. In the case of the State versus the Asante-Hines Divisional Courts, ex parte Kusada, Kusada is spelled K-U-S-A-D-A, reported in 1963 2 Ghana Law Report at page 238. The Supreme Court held inter alia that an applicant for an order of certiorari must be either a person aggrieved or a person who has a real or substantial interest in the proceedings sought to be quashed. The scope of the locus standi of an applicant has been extended by this court in the recent case of Republic versus High Court, who, ex parte Bediako II and another, Odum and others interested parties, reported in 2011 to Supreme Court of Ghana Law Report at page 705, in which the worthy president of this court, Doche JNC, after referring to the previous authorities on this point, notably Republic versus Polygon District Magistrate Grade 1, ex parte Ampoma, reported in 1991, 1 Ghana Law Report at page 353, and Apentin, in which deceased, Republic versus High Court, Accra, ex parte Apentin, reported in 2005, 2006, Supreme Court of Ghana Law Report at page 18, set at page 712 as follows, and I quote again. In the instant case, the applicants herein were the complainants in the criminal case which is the genesis of the entire application before this court. In that respect, therefore, the applicants must be deemed to have more than a sufficient interest in the matter to qualify them to sustain the application before this court. End of quote. It means that when you are applying for an order of certiorari, you need not be a person who must be a party, but you must only show that you are a person who has a substantial interest in the action before the court, or that you are aggrieved by that particular decision. So in this case of Republic versus High Court, ex parte Kofi Moabin and others, this is how the Supreme Court concluded. In this case, as the applicant was a sole complainant who had indeed given evidence before the trial circuit court, she had more than sufficient interest to protect than anybody else. It is also the duty of every citizen that justice must be seen to be done to all manner of persons by ensuring that the courts in this country established by statutes with limited jurisdiction observe the law within the statutory limits. Even though the learned High Court judge had jurisdiction to supervise the circuit court under Article 141 of the Constitution and Section 1C of the Courts Act 1993 as 459, his powers to supervise should be exercised within the limits imposed by law. The objection that the applicant has no locus standi is thus misconceived. What do we get from this case? What we get from this case is that when it comes to applying for an order of certiorari, there's no requirement that the person must be somebody that is somebody who is a party to the suit before the High Court. The court, we are being told from all the authorities, from ex parte Kusada, all the authorities, that if you are aggrieved by the decision, or you can show that you have been substantially affected by the decision, even though you may not be a party to the suit, you can bring an application and invoke the supervisory jurisdiction of the Supreme Court for an order of certiorari. Now, what we have done so far is that we have explained certiorari to be a question order. We've looked at the grounds under which you can grant certiorari. We've looked at the person that has locus standi to bring an application for certiorari. The next thing we need to look at briefly is prohibition. Now, the main distinction between prohibition and certiorari is this. All the grounds we have canvassed for certiorari will still apply. Except that for prohibition, the breach has not yet occurred. So let's say the public body is about to take a decision which is in breach of natural justice, or has assumed jurisdiction doesn't have, and they are going ahead. In that instance, you don't have to wait for them to finish. You can apply for such prohibition straight away to prevent the illegality from being perpetrated. So similar grounds like certiorari, but this one, it hasn't yet occurred, and you want to truncate and stop it from happening. And the distinction over here, you will see that you look at the case of Republic versus High Court, Accra, ex parte, Ghana Medical Association, Akman Akume, interested party, reported in 2012 to Supreme Court of Ghana Law Reports, page 768, specifically at page 769. And this is what the Supreme Court said, and I quote, "An order of prohibition or certiorari would issue to prevent a court or tribunal from exceeding or continuing to exceed its jurisdiction on grounds of want or excess of jurisdiction, error of law on the face of the record, failure to comply with the rules of natural justice, and the breach of the Wainsbury principle, namely that an administrative action or decision would be subject to judicial review on the grounds that it was illegal, irregular, or procedurally improper." And the difference between certiorari and prohibition was only that whereas certiorari would look to remedy past errors, prohibition would look to the future to prevent what was to be done from being done. Quote ends. So what are you being told in this case of Republic versus the High Court Accra, as per the Ghana Medical Association? They are being told that an order of certiorari or prohibition will be granted on those same grounds. You saw the grounds over there. They mentioned the same grounds from exceeding or continuing to exceed this jurisdiction, excess of jurisdiction, error of law on the face of the record, failure to comply with natural justice, breach of the same grounds, except that for prohibition, it looks to the future to prevent it from happening. But for certiorari, it looks to the past, to pass what has already occurred. The next point to look at is that must a person go through an appeal before he can apply for certiorari? The answer is that a person need not lodge an appeal before he can apply for certiorari. You can always go for certiorari whether you have appealed or not. But let me just be quick to add that there's an authority for the proposition that where in fact a person has lodged an appeal already, that is, if you lodge an appeal already and you're contesting the whole decision on appeal, there's an authority for the position that the court had the power to exercise its discretion to refuse a remedy for certiorari. Remember, certiorari is a discretionary remedy. So if the High Court has given a decision and you have appealed against it and you want to apply for certiorari, there's an authority for the proposition that where a person has not an appeal and is also going for certiorari, the court may exercise its discretion and then refuse the application for certiorari. And remember that the certiorari is a discretionary remedy. So the court is allowed to look at the entire circumstances to determine what is fair to be granted. And the authority for this position is the case of Republic versus High Court Accra, ex parte Ayiti. Ayiti is spelled Aryeetey, reported in 2003-2005, one Ghana law report at page 537. And if you look at this case and look at holding 5 of the head notes, this is what has been said, and I quote: certiorari was a discretionary remedy, and therefore the conduct of the applicant could disentitle him to the remedy. In the instant case, the court would take the circumstances of the case and the conduct of the applicant into consideration to deny him the remedy of certiorari. Moreover, since the applicant had an appeal pending in the Court of Appeal against the decision of the High Court, which he is seeking to have quashed, the court would not exercise its discretion in his favor. End of quote. So this case of Republic versus High Court Accra, ex parte Ayiti, is one of the cases in which we have been told that when a person has exercised his right of appeal, the court has the power to exercise its discretion to refuse a remedy of certiorari. So by way of recap for all that we've done in this lecture, we started with discussing judicial remedies. We mentioned that we can have them under private law remedies and also under public law remedies. We said that for the private law remedies, we can look at action for damages, injunctions, and declarations. And I indicated that even though injunctions and declarations are ideally private law remedies, they have become increasingly important and have been applied in public law these days by virtue of human rights and administrative law issues. We then went ahead to discuss some public law remedies, and we mentioned a number of them. We mentioned prohibition, certiorari, mandamus, and quo warranto, and also habeas corpus. And in this lecture, we have limited our discussion so far to the private law remedies of injunctions and declarations, and we've also discussed in extenso certiorari and prohibition. In our next lecture, we shall discuss mandamus, quo warranto, and then habeas corpus. But as far as certiorari and prohibition are concerned, we have looked at what certiorari is, that is a quashing order. We've looked at the grounds under which it can be granted in Ghana, that you can go to Article 33, Clause 2. You can also obtain it under Article 141 of the High Court Supervisory Jurisdiction, and you can also obtain it under the Supreme Court Supervisory Jurisdiction under Article 132. We'll look at the grounds for obtaining a remedy of certiorari: want or excess of jurisdiction, breach of the rules of natural justice, error of law patent on the face of the record. And we also seen that Wensby's unreasonableness are also grounds under which you can go for it. Taking an illegal decision, a decision which is contrary to the express requirements of statutes, you can also go for certiorari. And we saw in the British Airways and Attorney General that the Supreme Court can intervene and give orders whenever they think that they have to intervene to do justice. So after looking at the grounds under which we can obtain certiorari, we also looked at the fact that a person who brings an application for certiorari must not necessarily be a person who is a party to the suit. And we battle this with the Republic versus High Court, Human Rights Division, as per the now Otua's way, where the court had referred to the previous authorities and held that it's not only a person who is a party, but then it can also be a person who is aggrieved or has a substantial interest in the action pending before the court. Having looked at the people that have capacity to bring an application for certiorari, we now have to look at prohibition, and we mentioned that it had the same grounds that as certiorari, except that for prohibition, it looks forward to prevent the breach from actually occurring. So that if in the district court and you can see that they have assumed jurisdiction over a cause or matter affecting chieftaincy and they are going ahead, you need not wait for them to finish before you come and quash. You can go straight to the High Court, invoke a supervisory jurisdiction, and obtain an order of prohibition to restrain the High Court, the district court, from wrongly assuming jurisdiction in a cause or matter affecting chieftaincy. So for prohibition, same grounds as the certiorari, except that it looks forward. And remember, I looked at the case of Republic versus High Court Accra, ex parte Ghana Medical Association. Akmanakumi, interested party, reported in 2012 to Supreme Court of Ghana Law Reports at page 768. After looking at the distinction between prohibition and certiorari, we also mentioned that it is not necessary that a person must go through an appeal process before he can apply for certiorari. Meaning that if you appear before an adjudicating body, you appear before the district court and they give a decision which you think falls under any of the grounds under which you can go for certiorari, you do not appeal before you go for the certiorari. You can go straight to the High Court and apply for the remedy of certiorari. Remember, I gave you an authority that gives support to the position that because certiorari is a discretionary remedy, if a person has lost an appeal already, then the court may exercise its discretion to refuse the grant of certiorari in that particular case. And I supported this with the case of Republic versus High Court Accra, ex parte IET, reported in 2003, 2005, one Ghana Law Report at page 537. So this is where we shall draw the curtains for our discussion on the first part of our discussion on judicial remedies. As I indicated, in our next lecture, we shall discuss mandamus. We shall look at the grounds under which a person can be entitled to the remedy of mandamus. We shall look at quo warranto, and we shall look at habeas corpus. And that shall be the subject matter of our next discussion. This is where we shall draw the curtains for our present lecture. Thank you.